Thank you. Mr. Burns, please begin when you're ready.
Chairman Mann, Ranking Member Costa, and members of the subcommittee, thank you for the opportunity to testify today on behalf of NAMI, the North American Meat Institute. I'm Bryan Burns, VP and Associate General Counsel at NAMI. Prior to my time at the Institute, I worked 20 years in the industry, both as legal counsel and head of environment, health, and safety at 2 different meat and poultry packing companies. NAMI is the oldest and largest trade association representing meat and poultry packers, both large and small. More than half of our members have fewer than 100 employees. Make no mistake, our industry is facing headwinds, both due to economic factors and due to recent court decisions, proposed regulations, and laws that will negatively impact our industry and thus the consumers and customers we serve. On the economic front, fed cattle prices are at record highs. Our pork processor members are facing declining wholesale pork prices, and some of our larger members have seen reduced earnings, have been forced to lay off employees, and have closed facilities. These market dynamics have unfolded exactly as 4 member company CEOs testified would happen before the full committee a little over a year ago. And just this week, the Wall Street Journal ran an article on these dynamics entitled "The Big Meat Conspiracy Theory Unravels," and thank you to Chairman Thompson for inserting that into the record today. However, I want to emphasize that the industry is incredibly resilient despite claims to the contrary. Against challenges such as COVID, supply chain disruptions, labor availability, and the impact of drought, beef production set new records for 4 consecutive years from 2019 through 2022. Pork production has seen similar 4-year totals over the same period. The industry faces challenges on the judiciary, legislative, and regulatory fronts. The U.S. Supreme Court recently issued a fragmented decision to uphold California Proposition 12. That decision will trigger similar regulations in Massachusetts under their ballot Initiative 3. It will also embolden anti-animal ag groups to pursue burdensome laws elsewhere, and it will open the door to chaos in interstate commerce through state-by-state trade barriers, not just for meat and poultry products, but for any products not meeting the standards set by another state. Industry needs certainty, but any federal or legislative solution to this requires careful drafting to ensure it's legally sufficient to address the problem, but not vulnerable to legal challenges in court. USDA's recent round of proposed rules under the Packers and Stockyards Act is also a threat, both to packers and producers. The department should withdraw its entire suite of interconnected rules and publish them together, if they're going to publish them at all, with a sufficient comment period to allow stakeholders in Congress to consider the overlapping impact of the intertwined rules. The piecemeal approach that USDA has chosen in promulgating these rules is deliberate regulatory obfuscation. Courts have repeatedly held that the Packers and Stockyards Act, like other antitrust laws, is a competition statute. These laws exist to protect the marketplace and not to address individual grievances that could be decided in state courts. 8 federal circuit courts of appeals have held that a plaintiff must show harm or likely harm to competition to prevail in a case brought under the Packers and Stockyards Act. Yet USDA seeks to circumvent the court decisions and congressional intent and rewrite the Packers and Stockyards Act by regulation as a federal tort claim statute. The administration claims the proposals are needed because the injury to competition standard is an insurmountable bar for plaintiffs, and eliminating it will help rein in the big companies. However, the small family-owned poultry company I once worked for suffered a $14.5 million verdict in a Packers and Stockyards case that was decided under the injury to competition standard. That amount was large enough to drive that company to the verge of bankruptcy, and the result was that that company is now owned by an owner outside the United States. Small and medium companies stand much to lose from large verdicts in these cases. The most pressing day-to-day need for the meat industry continues to be access to a reliable, stable workforce. We are pleased that Chairman Thompson plans to establish an agricultural workforce working group within the House Ag Committee. We urge the working group to consider the workforce needs of our industry as it deliberates. We aren't eligible currently for the H-2A program, even though we are the harvest stage of the agricultural process, and we're essential to the food supply. We would welcome the opportunity to be a part of the discussion so that a solution can be found that works for all of agriculture. Another key priority is reauthorization of Lmr. Since 2020, Congress has extended Lmr's 5-year authorizations through the appropriation process. NAMI has since 2019 and continues to support a clean 5-year reauthorization of Lmr. The meat and poultry industry is a critical part of the agriculture industry. It provides an essential and nutritious component of Americans' diets. Thank you for the opportunity to testify today, and I look forward to answering your questions.